card for a parking problem.
Four in your 23.
Yes, that's 4 over the 28 from truck when you're ready.
Go ahead.
One truck, White Lincoln X-ray 985 should come back up next.
So you had 2000. Patrick Spalding.
10-4. If you can just put a little note in something like that, I might not be leaving a note on a vehicle if I can remove it.
Fuck. Fuck. Rockingham 505. 505 entered a vandalism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive that to 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4.
21.
No 3 in Depot Street. Truck way entry 5.
7435.
10-4.
10-4.
You go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4. I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
And 449, 1121, thank you.
10-4.
Code 4. 4.
Rockingham 535.
You have a great college.
535.
Should be. You guys know if our woman who plugged into a house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get in the bill. Now 5 people are on their hair, got tight shirt on, and number 21 is on.
We have separation. In or out. Good. Hey guys, we'll do about an hour show, I think, an hour-long show today. There was a hearing, so I like to come on if there's something relevant that happened. And we had a hearing on the Turtleboy case today. It was kind of interesting. And I'm going to play about 10 minutes of it for you guys from Melanie Little's channel. And, this is the thing. I don't really get why these people feel. So first I started out on the Glares channel, and he's constantly talking over the trial, the witnesses, not the trial, the hearing. So the attorneys and the judges. And he's even playing, he's got like little clips that he's throwing in, points that he likes. He makes a cheering sound or a booing sound. And it's not any attempt to be analytical or objective. It's just he's cheerleading the side that he's on, and that's it. Man, just let your audience, treat them like adults. Let them watch, and then you can have whatever kind of fun you want afterwards. But you're playing this live. If you want to do a replay of it later on and throw in your little stuff like that, that's fine. But if you're playing it live, why would you? What kind of audience do you have? I'm not talking about the size. I'm talking about the intelligence level of your audience. If they want to listen to a channel that does that. Now, I listened to it for a little bit because I wasn't sure where to find it today. So then somebody mentioned that Melanie was covering it. So I went to Melanie Little's channel, and that's where we're going to play from here. But it wasn't much better. She's constantly making remarks about it, and not in any way by no means anybody even attempting to be objective. And she's constantly sitting there making faces constantly during the show. You'll see it. It's really, really annoying. I don't really understand but they both had good audiences. I think one had like 6,000, the other one had 5,000 watching. What is it that these people want that? Like, I myself just want to go and listen to the hearing. But that audience doesn't want that. It's kind of like almost like like the black churches in the South, right? Where it's kind of a cool kind of lecture where the preacher is preaching, and every 10 seconds someone in the audience shouts out amen. But that's a different thing. You're trying to build unity in the mass there, or whatever not a mass, whatever you call it, the service. This is a hearing. And this is what these people kind of do. They just constant shout outs and stuff like that because it's this mindless thing where most of their audience just wants that. They want to all feel like they're thinking with one mind, and that's what's disturbing. That's why I call them the mindless mob. It's not that everybody in it, of course, not everybody in it is mindless, but that's the general effect of what you're creating there. In any case, I'm going to take a different approach. Now, as I always say, and you can drink to this, I am not a lawyer, nor do I play one on TV, nor have I written any characters that are lawyers either. I don't think. Can't recall any. I'm nonetheless still going to try to both sides this as we listen to some of the hearing today, because look, as just a practical understanding of how courts work, there are two sides, and it's a hearing. So you're two sides with lawyers that are making an argument before a judge. Now, presumably, all those lawyers involved went to law school and have experience before a court. So there's a degree of validity to each side's point. Just generally, that's how it works in court. And the judge, has to referee that. So if there's any place where someone should at least make an attempt to look at something from both sides, this is it in a court, right? When you have lawyers making these arguments against each other. Now, unfortunately, because I'm not a lawyer, that will limit my analysis, but I'll try to give it that kind of common sense approach to it, and look, we all know what's at stake here, and we all know how I feel about it. I believe that what Aiden has been doing for the last year and a half, and Karen and her lawyers are a part of this, is dangerous in terms of trying to intimidate witnesses to change their testimony or silence them in order to try to silence anybody else who wants to speak up with their opinion. But there are legal issues here that sometimes get into gray areas of the law. right? We all of us believe in the First Amendment. Even Turtleboy, even though he spends much of his time trying to silence free speech, but he doesn't. But he believes in the right to free speech, at least his own free speech. He'll try to silence everybody else who might disagree with him by threatening to smear them or their families. But other than that, he believes in free speech. The glare, it's kind of hard to tell what he believes in. He just believes in donations, I think. Let me just take a sip of coffee. This is my after supper coffee, and because I'm doing the show early because Kate is I was misinformed by our great friend Nima, who you see here in chat, who is actually in Sweden, so she had the time zone mixed up, and she told me Kate was going on at 8, and I was like, oh, okay, I don't want to interfere with her show. Not that, I mean, our audience is pretty small, but I mean, I know a lot of you guys here will like to go to her show, so I figured I better come on earlier, so I scheduled it for 8. And for 7. But turns out Kate is going on at 9. So in theory, if I wanted to, I could stay on all the way to 9. But I do want to go watch the Celtics tonight. They're playing the Miami Heat. So it all works out good. We're just all here, those of you here with me, a little bit early. Let me take a sip then. Thank you. Sorry, Tom. Oh, that was a good cup of coffee. All right. So the issues before the court today in the Turtleboy case, as I load this up, all right, so Turtleboy has 2 lawyers representing him now. One is Bradle, and he's been with him for, I think, all along, certainly over a year. And the other one is Betero. Now, look, there's something we have to understand. So when I made the thumbnail for this, I showed a bunch of lawyers chasing an ambulance. This is a reality of this. I know it's a cliche, but even good lawyers like David Yannetti. Now, David Yannetti was a prosecutor in Boston for 10 years. That's a long time. He graduated, at or near the top of his class. He's a smart, capable man. And he's an effective lawyer, an experienced lawyer. He's been a private lawyer now for, I think, 20 years. He's been a defense lawyer. But before that, he was in the prosecution in Boston, so a prominent position for 10 years. And he, for instance, prosecuted the case where the 10-year-old boy that was killed by 2 guys in a sex crime, Jeffrey Curley, I think his name was. So he prosecuted those 2 guys successfully. And then when he first left that to go to private practice, he got a big victory there. He got a guy that had been in jail for 10 years, guy who was mentally, I can't think of the politically correct way to say it, but a little bit on the slow side. And he managed to get him a new trial and then win his release from prison. So whether that guy was ultimately guilty or not, that's a big victory for a lawyer to get him out. So you would think that Yannetti would be hugely in demand, right? But I think this is just being a defense lawyer turns out to be, unless you're Alan Jackson, right, and you're dealing with Hollywood, it's a tough grind of a job. You're getting all different kinds of clients, and the fact is that most of them are finding you through your website. That's how Karen found Yannetti. And Kevin Mahoney had explained to me that that's how probably standard, that even Yannetti had been frustrated with that and saying that most of his business was reaching him through the website. So you're not exactly, now Alan Jackson claims to be in a position, and he probably is in a position to kind of pick and choose his clients. But most of these guys aren't it. They're taking what comes their way and they're doing their best to defend them. And it's a grind and it must be difficult. You're defending a lot of people that are real scums of the earth, but maybe some of them are drug dealers, so they have money and stuff like that. So this phenomena is affecting what's going on in the Karen Read case, because you now have numerous law tubers who are emerging and that are realizing that if they make themselves known on YouTube by doing a lot of appearances. As long as they push the conspiracy and as long as they push defending Turtleboy, it's going to get thousands of views, and that's going to bring them a lot of business. So Melanie, in this, you'll see in this video here, let's see what it has for views. Now, this was from today, and at this point, it has almost 40,000 views. That's a free commercial for her. Okay, she's putting this up here, and she didn't have to pay anything for it, and she's going to get 40,000 people to see this. So her name is out there. And I don't even know if Melanie works as a defense lawyer. I don't know what kind of, I think she maybe did real estate law. I'm not sure. But in any case, even as a real estate lawyer, she's now getting her name out there. It's very valuable. And the way to do it is to grift on one side. And that's just the way it is. So Betterow was a guy that emerged in this way, and he started going on Young Jelly's channel all the time. Now, I watched a little bit of it because I want to hear. I don't mean today. I mean in the past. I don't watch Young Jelly's channel, but I went on a couple of times to watch a little bit of Betterow because he's a lawyer, and I want to hear what professionals have to say, whether they're in law enforcement or lawyers or medical examiners, whatever they are. And that is of interest to me. But Betterow struck me as, and I'm going to say that I'm sure this was, and I even admitted at this time, I'm sure he's no dummy. But the stuff he was saying on the show was particularly dumb on Young Jelly's show. But I think it's because sometimes in this case where you're trying to continuously spin a conspiracy theory that just doesn't make sense, especially the deeper you dig into it, you're kind of forced to say some dumb things. That's your choice. And so let's just take someone who's not a lawyer, for example, and M. William Phelps. I think he found himself in that predicament. If I cover this from the pro-conspiracy side, I'm going to look like an idiot. And he chose not to look like an idiot. So he came down on the other side. And that's the only side you end up on if you really follow the evidence deeply and follow through the logic. Now, again, there are plenty of intelligent people out there. In fact, I just heard recently about a retired judge who said her opinion, oh, Karen must be innocent. But she didn't know the evidence of the case. She only knew a few superficial things that she hears about, dog bites and butt dials and stuff like that. So I'm not talking about them. There are plenty of intelligent people that just have a very cursory view of this case, and they only know the things that are odd. Things that have been explained in most cases, but that's why they're focused on that. They haven't had the benefit of being able to dig deeply, look at all the evidence, watch the whole trial, read all the documents, and nor should they have. But for people that do spend the time to dig into this, so obviously Phelps had to do that for the making of his podcast. You can't. You find out there's no way to take the side of the conspiracy because there isn't. You get deeper and deeper into absurdities, like where you're trying to say that these guys took John out alive, knowing he was alive, and put him out to die on their own lawn. Now, that's crazy. All right. Now, you may not completely dismiss the conspiracy at that point, but that ought to have at least aroused your sense of skepticism about this theory because it's pretty bizarre, right? Why wouldn't you, if you're going to put him out, why wouldn't you kill him before you put him out so he can't be revived and tell the police what happened? Or why wouldn't you put him on the neighbor's lawn or get rid of the body? I mean, I've never heard of a case where people would intentionally put him out on their own lawn. And the theory too is that they told the McCabe's before they left. That's the plan that later on they're going to put him out on their own lawn. That's bizarre. Nobody would think that way. Nobody would. It's so you don't dismiss. There are plenty of real reasons to dismiss the theory in terms of evidence. There's real proof on this case that shows. I'm trying to be careful how I say this to be fair, but that really shows that the prosecution's case is pretty likely to be well beyond a reasonable doubt once they get to it, if they present it properly. But even before you get to that, you should have been asking questions like that. And so somebody like Phelps digging into it is going to ask those questions, and he's going to keep digging deeper and deeper. And then he has the benefit of going back to look at the testimony in the first trial. And there's no way, unless he wants to see people laughing at him down the road, he's going to come out on the side of the conspiracy, and he didn't. But this is what's shocking to me here is how many of these lawyers are going out there and grifting on this, because they're not even making an effort to try to see this, like even just on a narrow. So now Turtleboy is a separate case, and there's a compelling amount of evidence that shows that Turtleboy was trying to intimidate and hound the witnesses. It has nothing to do with his role as a journalist. It's compelling. Thank you, Thomas. And that's there. Now you can debate other points of law here as to whether the First Amendment protected any of that activity, right? That's fine. You can have that debate. But to just come out and automatically assume that Aiden is innocent, it's not because she's assuming that. She's just taking a side in this because she's grifting on the Karen Reed case. All right, so let's I skipped over here the Brado part. So I think the only two things that they were looking for here, the defense was looking to get back Turtleboy's phone physically, and also the extraction from that phone. So all the data that was in there that the police took. And he did get the extraction of those phones back by the end of today. By the end of today, he was given a thumbnail, so he has all the data from the phones. Does not have the physical phones. Turtleboy lied about that, but that's my understanding anyways. The second issue was, and this is where they bring in Betterow, is to go after D.A. Morrissey's private communications. And so we'll dig into that as best we can with my non-legal lawyerly analysis. I should say my non-lawyerly legal analysis is a better way to say it. But Betterow, again, was, and I think there are times he argues well today here. So this is where he's not an idiot. When he was saying those stupid things on Young Jelly's channel, a lot of that was because he's talking to Young Jelly, and that's the role he had to play, and he's talking to that audience. So he's a grifter is what he is. He's someone who is trying to make a name for himself. And because of his work on Young Jelly's channel, he ended up becoming Turtleboy's lawyer too, joining Bradle on the team. And again, so now he gets his name out there, and he'll get a lot of business out of this. That's what ambulance chasing is. Not trying to disrespect the whole profession, but this seems to be the way it has to be in order to thrive in that field of work for a lot of people. And that doesn't mean that all defense lawyers will do this. Most of them won't. But there's no shortage of them now on YouTube that are doing this. All right, so we'll have to do our best to get through Melanie's constant face expressions here. So this is Betterow. So what happened was he filed a Massachusetts version of a FOIA, a Freedom of Information Act. I think it's called the Public Records Request. And so he didn't file it himself, though. And you see this comes up. This is a pretty interesting. This is probably the most interesting part of the trial. It comes up about 10 minutes into this clip. And so that's where we'll stop pretty much. But you'll have to decide as you listen to this, did he lie to a judge? Okay, but we're going to try to be as fair as we can about this. Okay, so let's go. Let me make sure the volume's up.
To the attention of the court.
Hold on one second. I got to switch my speaker.
But there's no procedure that I'm aware of where you screen for every conceivable privilege in the world.
Okay. With respect to the Rule 14, Rule 17, Mr. Betterow?
Go, Mark.
Thank you, Your Honor.
Here we go.
We recognize that this is an uncommon
So just to stop really quickly here to set the stage for people. So the Rule 17 is to compel evidence here to be obtained for the state or turned over, in this case, by the DA's office. So the DA's communications normally are done over his public phone. I mean, his official phone. And so those would all be something that the defense teams can get. Same thing with his emails. But in this situation here, he did use his private phone and his private emails, it seems, but for a very good reason. Now, whether or not that reason, how that plays out with the judge, he's going to have, the judge is not going to look at those, the judge may be aware of it, but in terms of what's presented in the court here, they may not affect the actual legal reasoning here. But what was going on was, so Chris Albert went to the Stoughton District Court to apply for a protection order because the mob was harassing him. And this is a difficult process. You're trying to figure out, you're trying to do that thing on your own and trying to figure out, you're trying to use legal means to protect yourself when you're under siege from a mob, literally. And the initial protection order was denied, but there's a leaker somewhere. Now, the suspicion here was that it was actually someone that works for the Stoughton District Court. And that person leaked that application to Turtleboy. Now, Turtleboy is the person who is primarily behind the mob and who is individually himself doing the harassing and the witness intimidation. So it's leaked to him, and then he uses it on his show to further harass them. You see the kind of irony here. This is what necessitated the need to use private communications. So what happened was, once that was denied, the families, or at least Chris and I think Jen McCabe, representing their families, went to the DA's office. And they said, you got to help us here. What do you want us to do? You want us to, if you're not going to help us, they didn't say this, but I'm sure most of us in normal situation would say, hey, what do you want us to do? If you're not going to help us, are we entitled to help ourselves? What do you want us to do here? We're under siege. And it's affecting our business. It's affecting the lives of our children. It's affecting special precautions have to take place in their school systems. It's a true mob here. Now, it's a unique situation. It's hard to think of too many other cases where something similar to this has happened. Maybe not any. But you have to do something to protect us. And I think the DA felt that and tried, but also was aware that had leaked to Turtleboy, the first attempt a few days before, was trying to cover, slash his T's and dot his I's in doing this. But he knew that some of this communication had to take place outside of means that it would be discovered. Because if it's discovered, so in this case, it would have been, this is before Turtleboy had any charges. So if Karen Reed's lawyers had discovered this, which they would have if it was part of the normal public procedure, they would have given that to Turtleboy to further intimidate them. Now, if someone thinks I'm making an unfair accusation to Karen's legal team, go to hell. Because we know exactly, it was documented, how many communications Alan Jackson and David Iannetti had with Turtleboy in those opening weeks of getting this mob going. And that Karen was in communication with him every day. All right. So if that information ends up in the hands of the defendant and their legal team, it's going to Turtleboy, period. And he's going to use it to further intimidate and harass the witnesses, period. There's no question about that. You can't even argue it, because even if you were to say, well, whatever communications they had with Turtleboy, we never instructed him to go and harass anybody. But who knows what the truth is there? Turtleboy himself told his admin team on May 3rd of this past year that Karen was directly involved. But in any case, those lawyers certainly knew what Turtleboy was doing, and yet they were still trying to keep him on the team. And Alan Jackson reached out to me in August through Turtleboy. Turtleboy was the one that contacted me. Now, what did Alan Jackson want? We can only speculate. He said he just wanted to. I messaged him, and I said, I'm going to cover this both sides. And he said, well, I just want to touch base with you. So I don't know. It's possible he just wanted to see if I had any information on the case. But that seems unlikely, right? So who knows? But they knew what Turtleboy was doing, and yet they were still fully in his corner, and still are. So the idea that there's no way the DA could allow any of that information to get to Karen's team. So I presume that's what necessitated the private communications. But those messages were copied to the other assistant prosecutors and the judge involved, I think the Stoughton judge. So it's not like some secret message thing going on that we know of. Of course, does Turtleboy's defense team have a right to get all those communications to make sure there wasn't something? Arguably, yes. But if Melanie Little's going to take a both sides approach to this, she should be able to tell people that's was going on. But she's not an honest broker.
Task to ask to seek to review the email of the elected district attorney. But this is an uncommon situation, and it's a situation that the district attorney himself created entirely.
And it was created by an email that he sent, or a communication that he sent to the district court.
This is Betterow talking, by the way.
Chief Justice and others about a potential leak of information from the Stoughton District Court.
On his private email.
Okay.
Oh,
There is also evidence.
Let's assume it was his office email. The analysis wouldn't be any different, right?
The analysis wouldn't be any different,
Okay.
but we would have no reason to suspect that this was
So that's Betterow and the judge talking to Betterow.
occurring, and in the context of seeking a Rule 17 subpoena and what is considered phishing and not, it is not an everyday situation where somebody just starts demanding the email of the district attorney because maybe he did something. What I'm suggesting to the court is, on that one example, on his private email, which we believe could lead to the inference that that is designed to subvert public records laws, that he sent that, and most importantly, that email directly talks about Mr. Carney in the context of alleged witness intimidation, communications from witnesses who are going to testify against him, and an email.
So again, this is where I like I said, I want to try to both side this, and this is like, it does seem like a difficult, thorny issue. On the one hand, the DA has to protect the witnesses. He knows there's leaks, and he knows the threat is actually from the other side, the defense team and the defendant. However, and now that we're getting on to the Turtleboy case, and this is Turtleboy's hearing here, what if there's, for instance, a message from the DA to a judge or an investigator that makes clear that they have their own bias against Aiden because of the threats, because of the witnesses complaining? So is there something in those messages that would display a bias that they want to hide from Turtle's defense team? So, so there is a valid case to be made to getting some of this information. At least, I think maybe hypothetically, that's all I'm saying. I'm not a lawyer, so there is issues on both sides here.
Email, which also included text messages from Jennifer McCabe, who is a key witness against Mr. Carney. Additionally, since this motion has been filed, we even learned just last week from the Karen Reed hearing that Mr. Morrissey uses his cell phone to communicate directly with witnesses in the case against Mr. Carney, and those materials are going to be provided to Ms. Reed's attorneys. But we also learned that as it relates to Mr. Morrissey's use of his cell phone, that he set his phone, his iPhone, and our subpoena would be to Apple, he set his iPhone to a setting to auto-delete all of his messages every 30 days, which I would suggest to this court.
So the DA's phone, as we learned last week at the hearing, is set to automatically delete after 30 days. So, what is the meaning of this? Is that a way of hiding information from future requests like this? I don't know. Is it just a way to clear up memory on his phone? People can decide what they think the case is, but what's going to matter is what legally can be proven. So in terms of going after the DA's ex parte communications, his private communications, that's not what ex parte means, one party, but his ex parte communications through private devices or emails, it can't be a fishing expedition. They're going to have to demonstrate to the judge that the information they might get on those emails is both relevant and material. And those are relevant and material they're kind of similar things, but anything that is material is also relevant, but some things could be, in theory, some things could be relevant, but not material. So something that's material really goes to the heart of the charge, whereas something that's relevant could be related to something that's an issue in play. But it has to, you have to give them an idea. You have to give the judge a reason to think that there might be something in those messages that would be relevant material to the charges against Aidan Kearney. They also must be specific. Can't be overly broad. The idea is protecting everybody's privacy. Everybody has a right to it. You, me, Turtleboy, and the DA. So, for instance, you wouldn't be able to get messages between the DA and his wife, right? So you want to give specific things. And going back to, for instance, the hearing last week on Karen Reed, David Yannetti gave, so Attorney Brennan was cooperating with going through those messages and not going to just turn them over, but search for certain categories that could be relevant. And Yannetti said, look, these are words that we want included on that. And so I think you probably might see something similar to that here. I don't think it was ruled on today. The judge tabled it to be ruled in a couple of weeks because not all the X's and O's were provided here in terms of affidavits and all that stuff that were necessary. So if the judge decides that there's a way that this can be, if he decides that it is relevant material and that it's specific about what they're looking for, they can, and there is a motion by Bettero here for this information. So they could rule in a way, the judge could rule to that in a way that would compel the DA to produce this stuff. But the judge is going to have to balance the need, like with anybody, the need for there's some different issues actually with the DA. He's going to have to balance the need for these communications against any potential harm that it could do to the DA, because he's got a distinct job. Could it affect the way he does his job? He is the chief law enforcement officer in that county. And so there could be privacy concerns related to that. So they're going to have to be very specific about how they have to take into account his duties and whether this affects that. So, but what exactly that means, that's where there'll be case law that will be applied for the judge to use as a guideline.
Further evidence, possibly, of an intent to deprive what ought to be discoverable, whether it be in Rule 14, which we'll get to, or in getting access to relevant communications from his private server. When you factor in together, and this is an important backdrop before I get into the factors.
Do you think his server maintains the content of his communications that he auto deletes?
I'm sorry?
You think his server maintains copies of the content of his communications that he auto-deletes?
I
Apple
believe
would?
that Apple has the ability, absolutely, to maintain deleted messages.
Do I have an affidavit or anything else from you to that effect?
No, you don't, Your Honor, but I would.
Do I have any factual submission that will find anything in the content of an Apple subpoena that we couldn't otherwise get from Mr. Morrissey?
Well, I'm going to get to that when I get to the Rule 14, certainly as an alternative argument. But to answer Your Honor's first question, every day in this court and across the country, when you hear about so-called Celebrite extraction reports, deleted messages, of course, appear. They do remain on an Apple server. Just because the user may delete them from their device, I would suggest the court and
All right. So so Tom messaged me that people want something that's going on Court TV to be covered. What exactly is going on Court TV? And is it on YouTube Court TV or their website? I'll look on their YouTube. I mean, I wouldn't think there'd be anything live going on right now, but maybe there is. Doesn't seem to be anything live going on at the moment. I'll go to their website. So it's Sarah Boone being sentenced in the. No doubt that's really interesting. It's just not something I've been covering, and doesn't seem to be live either. But let's see, watch live. I don't know. I don't get it. All right, let me continue.
anyone else, that those messages we've all seen can be pulled back and just don't simply delete.
You want me to take judicial notice of that?
I'm not necessarily asking you to literally take judicial notice, other than I would suggest that is a very common thing. And one should not assume that just because a user deletes an Apple message from their phone, that it is somehow lost forever. The purpose of me mentioning to Your Honor text messages at all leads to why we want Apple to capture the universe of the email communications that we request from Mr. Morrissey. The fact that he does have it set up to auto-delete, the fact that he...
Oh, I get it. So you have the Court TV feed from the hearing today. Well, there's only I think about 5 more minutes I'm going to play of this. So at this particular segment of it, Melanie's relatively quiet. So we'll just stick with this.
He does use private email to access business. Doesn't give us confidence, respectfully, that things are going to be preserved for public records or for disclosure to defendants. Additionally, Your Honor,
More
we
sign.
now know that the use of the iCloud email by Mr. Morrissey to conduct business is not a one-off. It is not simply the
Not a
one
one-off,
message
he said.
that ended up in the hands of Mr. Carney's defense by way of a third party. And I will address this, as I'm sure Your Honor will have questions about a public records request and a response to that as being relevant to whether information is procurable from another source. But it's simply important for the court to know that we now have irrefutable proof by somebody who did a public record search, I have learned, and received.
Somebody who did a public record. This is where it gets interesting, guys. So I know it's been boring so far. This is only a few more minutes, but this is really interesting. Someone who did a public record search, I learned. Now we know who did it. He knows too.
Some degree of a response from the district attorney's office that Mr. Morrissey has been conducting business on his personal iCloud account since at least 2020. And the last email that was turned over as part of that public access request just happens to be the September 2023 email regarding Mr. Carney, along with one response from, I believe, the chief judge saying you need to raise this with the Stoughton District Court.
Oh, they got a response
It
from
is in
that?
that backdrop, Your Honor, that we require a Rule 17 subpoena for this iCloud account because there is just no reasonable basis to believe that all of the information will be maintained and will not disappear based upon his use of the private server and his auto delete of the text message.
And
So I think what he's saying reasonably is that the fact that the DA's office did reply and did send some messages tells them there are messages. But now what they're saying is they want to get a subpoena for the iCloud under the idea that the DA's office may not have sent all the messages or may have even deleted the messages, and based on the idea that he's set his phone to delete every 30 days. That's the arc. Those are the way they're going to connect the dots here. I'm not a lawyer, if I understand that
in
right.
other words, Marcy can't be
As far as
trusted.
the relevance under Rule 17, it shows again his direct contact with witnesses and with officials regarding things that directly relate to Mr. Carney and his alleged witness intimidation. Notably, the email in question was sent on September 28, 2023. There are documents that are exhibits in the letter that I wrote on October 17th, which I know Your Honor has read, that indicate that Mr. Morrissey had already recused himself officially from all matters involving Mr. Carney by the 26th of September at the absolute latest. This information, if there are other messages, would be relevant to show his personal interest in seeing Mr. Carney prosecuted after he had been recused,
Mm-hmm.
the bias of his office, and as Mr. Bradle referenced earlier, the bias of the very witnesses in this case, both police and civilians.
So I think what he's saying is, so they, just to add what I said before, so they have evidence that he's used these private accounts. He's communicated with at least one of the witnesses against Aiden, which was Jen McCabe, because one of the counts of witness intimidation was against was against Turtle trying to intimidate Jennifer McCabe. And so you're establishing the relevance there. And they're saying that the DA, when they prosecuted Turtleboy, they recognized the need to recuse themselves from it. So they went out and got a special prosecutor, and was Mello, and who was represented here by Cosgrove. So it's not rocket science to make that legal argument, but it's a reasonable argument to say you've established enough relevance and specificity there. The specificity is we want to know, for instance, what messages he had with investigators about this case since he recused himself from it. What messages did he have with judges regarding this case? I think it's a fishing expedition, but a reasonable one. I don't think it's likely to find anything, but we can't know, right? So I do believe, I predict the judge will allow something here. They'll probably try to work out something where they are able to search for certain communications with certain people. So, for instance, what communications did he have with Jen McCabe or Chris Albert? And certain search terms and stuff like that. So it is a fishing expedition, and Melanie here is making her kind of goo-goo eyes, but she doesn't want to tell people. The reason DA Morrissey is communicating with Jen McCabe is because Jen McCabe came forward to complain about the harassment of her and her family by Turtleboy and his mob. All right. So she doesn't want to tell you that, but we in our audience understand that.
Additionally, as Your Honor has taken the suppression undue delay motion under advisement, accompanying the email that was disclosed by the clerk of the Stoughton court to a former clerk of that court included pages of the extraction report that we now know existed as early as October 11th, 2023, which was only disclosed to the defense on December 2nd, 2024.
Today.
There could be relevant information contained therein that could very well shed light on whether any shenanigans, as Mr. Bradle alleged, occurred in why cell phones that were searched, at least two, is the common.
It's again, this is like annoys me. Betterow, who is her guy, right? She's on the same side as Betterow, is making an argument, and she's going to stop to yell shenanigans. I mean, come on, Melanie.
Well, now concede, at no time were ever disclosed, and indeed representations were made again and again and again, suggesting they were pristine and unsearched. As far as not otherwise being procurable in a reasonable manner. The obvious response to that would be, well, if there's a public records request that was satisfied, then, you know, you go through that process, and isn't that another way? And in these circumstances, for some of the reasons I said earlier, we don't believe so. Number one, the person who answered the public records request is literally an assistant district attorney who is literally a subordinate of Mr. Morrissey and reviewing their boss's email. Now, if something were to come...
It's no different than any other Rule 14, right? I mean, the office has an obligation to turn over any discovery materials, right, in the office.
Yes.
An assistant DA reviews the files. That includes the DA's files and anybody else who's, you know, part of the prosecution team. It happens day in and day out, day in and day out.
It does, Your Honor.
It does, Melanie. Now, it's a semi-legitimate point by Betterow, but it is what it is. At some point, you have to trust the courts to police themselves and the police to police themselves. When it's sometimes if you can get somebody independent, but that's not how it works in this situation here. What are they going to do? Bring in an attorney from a different court to try to review these, to decide which messages might be relevant or pertinent to the case? So I don't know what the solution to that would be, but the judge is saying, look, these people are professionals and they don't want to get in trouble themselves. So at some point you have to trust them to make unbiased professional decisions.
Honor, respectfully, what does not happen day in and day out is the elected official district attorney who has been recused from a case is talking about the very case, talking to the witnesses, talking to the detectives. That is absolutely not normal.
That's right.
And in the normal review of discovery, which
It's not normal but it's of course, but it's not usual for a case where the defendant whips up a social media mob, including Melanie Little, who's part of that team, a mob whose activities include going to a youth lacrosse game of one of the witnesses and hounding her, of hounding people outside their businesses, of doing a rolling rally where you stop at every house and scream with bullhorns and tell the neighbors that they're murderers and spit in their driveways. That's not normal either. Do you think that's normal, Melanie?
we'll get to in a minute with Rule 14, I don't believe it is normal for somebody to say, let me look at the district attorney's email. There would be no reason to even suspect that, let alone his private email and private text messages. This is, as I said earlier, Your Honor, not a common case or situation at all. Now, having reviewed the response to the Freedom of Information request, it is clear that there are materials that were withheld. Now, I suppose we could go...
What Freedom of Information request? You made one?
I did not make...
Who made the Freedom of Information?
I don't know who literally made it, but it has come into...
What is it that you're talking...
All right, so pay attention here. This is the interesting part. This is what I did a poll on this on Twitter. Now, I can't say with any kind of proof, but there's reasons to believe, again, I want to repeat before Mark Betterow wants to sue me, I can't prove it, but there's evidence that that Freedom of Information request was made by Turtleboy's mom, his girlfriend. Possibly I'm hearing that she didn't sign it either. She put down a fake name. I believe she put, I'm hearing, again, I don't know, I'd have to, but I'm hearing that she used Kevin Reddington, but intentionally spelled Kevin, Kevyn. But now Kevin Reddington is a lawyer, very well known and respected lawyer in the region that is, I think, connected to the McCabe's, or at one point represented the McCabe's, or Jen McCabe, maybe. So it's not an accident that that name was put down there. But they're trying to make it sound like this is all anonymous. Now, Turtleboy's girlfriend is not a lawyer. She almost certainly had help preparing this. I don't know who. I'm suspecting it's a guy who's only about 5 feet tall, but I don't know. Now, when I interviewed with M. William Phelps, he told me that the day before, he had spent the whole day with Turtleboy, Betterow, and Meredith. And he was actually impressed by Betterow. And it was clear to me that there was a lot of discussions with them of Aiden's case. Now, beyond that, I couldn't say. I'm not accusing anybody, but seems this is around the timing that Freedom of Information form would have been being filled out. Again, I'm not accusing anybody of that. But the idea that Betterow does not know who sent that in is absurd, but you probably can't prove it. But he's in a court of law facing a judge. Let's rewind that a second for just a few seconds.
No reason to even suspect that, let alone his private email and private text messages. This is, as I said earlier, Your Honor, not a common case or situation at all. Now, having reviewed the response to the Freedom of Information request, it is clear that there are materials that were withheld. Now, I suppose we could go.
What Freedom of Information request? You made one?
I did not make.
Who made the Freedom of Information?
I don't know who literally made it, but it has come in.
What is it that you're talking about that you're reviewing, or that the court should consider with respect to freedom? Who made the Freedom of Information request?
I don't know who made it, but it is certain.
He's saying he doesn't know. He said it twice now in front of a judge. Okay, this is forever, Betterow. You've now just did this in a very high-profile case that you wanted to insert yourself to. You stood before a judge, and you said that.
What did it ask for?
It asked for Mr. Morrissey's email.
So you must have the written letter that was the request.
I do, sir.
Who was it signed by?
It is signed by Brandon Hunt, Assistant District Attorney.
Okay, so the Brandon Hunt, the ADA, made a public records request.
No, signed the form. I misunderstood Your Honor's question.
He's playing games here. He knows that the judge is trying to find out who filed for the Freedom of Information records request, and he's trying to avoid telling him.
It's an anonymous person with an email, a Gmail account.
An anonymous person made.
It's an anonymous person with a Gmail account, and somehow that found its way into my hands.
A public records request.
Yes.
Okay, and that was responded to by an ADA.
Yes.
Okay, have you made a public records request?
No.
Okay, why not?
Because I make
You're
motions,
relying
Your
on
Honor.
an anonymous email public.
Because he's trying to avoid going through the Rule 17 process to get those communications initially by having that. He's using this to get evidence through a back-channeled way that they can use to argue for those motions.
Public records request?
Judge, I'm relying upon the response of an Assistant District Attorney who has responded to that and supplied.
Have you seen the request?
Have I seen the actual request?
Yeah.
I have not,
Okay, so how do you know what was asked for?
because they supplied emails, Your Honor, 200 and something pages from 2020 to 2023. The reason why we could make that request, it's going to be the same response. We have to review those materials. They're withholding materials as is indicated in the letter. We could appeal that determination. That could lead to somewhere else. That could lead to litigation. And I would suggest to the court that it is not reasonably a reasonable opportunity without the risk of delaying this for months and months and months.
What's unusual is somebody coming into court here relying on an anonymous public records
Oh.
request made by somebody we don't know,
You're shaming
requesting God knows
him?
what.
He's not shaming Melanie. This guy is standing before a judge saying that there was an anonymous request that he had nothing to do with and doesn't even know who it is. The judge has a right to ask that.
You're coming in here as an officer of the court saying I should rely on that and I should rely on the response. That is very unusual.
Well, that may be, Your Honor. What I'm simply saying is I'm not asking you to rely on anything other than, and I believe these emails have been actually supplied in another case. So the prosecution obviously is vouching for the records that were disclosed. They've been turned over, my understanding, under a protective order in another case. I don't think Mr. Cosgrove is going to dispute that. It is signed by an assistant district attorney. What I'm suggesting is to go through this process when the person who is determining what that evidence will be is the elected official subordinate combing through his email, that we lack confidence in that, Your Honor.
All right. It seems to me that this can be handled as a Rule 14 request, no different than any other Rule 14 request to a prosecutor.
If it prefers the court, I will certainly jump to the Rule 14 components of this.
And what is it that you would be making the request for under Rule 14, and why should I consider it before you've made the request? I mean, a Rule 14 is a discovery request. You say, we want X, Y, or Z. Have you made a Rule 14 request?
Many.
And where will I find those? And do we have a motion to compel the Commonwealth to produce certain discovery that was requested under Rule 14?
Judge, they are referenced in the letters that were sent to Mr. Cosgrove, to which we have received in his response papers some degree of a response, and that he agrees to provide us with text messages.
Okay.
So I believe, certainly Mr. Cosgrove is aware of our demand.
But I am not. You're asking me to compel Rule 14 discovery, and I don't have the requests submitted to me.
They were made in August of 2024, Your Honor.
That was a follow-up.
So
It was a May discovery.
all right, but I don't have those. We're going to go back to those discovery motions and revisit those now. You prepared to argue those now?
Yeah, let's do it.
I mean, I'm prepared to have you talk about discovery issues, see if you can resolve them, and if there's anything that the court needs to resolve with respect to emails from the district attorney or any subordinate of his, or other kinds of discovery that there's a dispute about, I'm happy to hear you. But it seems to me in the first instance, you folks ought to talk about it and see if you can resolve it. Does that make sense?
It's been over a year.
Okay. All right. Are there any other motions that I need to deal with?
Not from the defense, Your Honor.
Okay. Let me just see for a second.
This is wild.
Okay, so I think that's enough on that. It is frustrating watching the Massachusetts court system work. I mean, it was frustrating watching that damn trial last May and June and however many months it took. They don't have their act together. It doesn't seem like they have their act together here. It sounds like there were motions there. The motion goes to the court, but somehow the court didn't know there were motions there. That's frustrating. I don't really understand it. I don't really get it. I don't know if there's I can't think of any excuse for it except for the utter consistent incompetence of this state at every level. It's the registry of motor vehicles from the judges on down. That's the way it'll be. But that's not the same as corruption. That's not the same as an attempt to railroad or frame everybody involved. Do these people seem competent enough to frame anybody? No, they don't. It takes a lot of work to frame someone, I assume. There's a lot involved. And these people aren't competent enough to frame anybody. I mean, you might get something like on the show 2.5 Men where when they were kids, and Charlie stuck silly putty in Alan's pocket, and Alan got nailed for shoplifting as a little kid. That's about it. I can't see them being competent enough to do any kind of framing beyond that. They're too inept. So things that should have been settled today get pushed down yet again. Now, some of this slowdown is because obviously Mello is suffering very difficult health situation. But again, that's not new. That's almost been going on for a year. Judge Cosgrove is handling it for him. I've been told Cosgrove is brilliant. And actually, I went over the motion on this, the reply to the motion on this last week, and it was brilliantly written. I mean, I was thinking it was McLaughlin that wrote it, but it was actually Cosgrove, is my understanding, and it was brilliant. So, an older guy, but definitely very, very capable. But still, what is going on here? Why does it take so long? Why do they have to waste so many hearings on these things? It's just amazing. But I don't understand how people like Melanie Little can just completely ignore what's going on here, that these witnesses came forward because they were being hounded and they wanted protection. I don't get it. So, Marlene, I clicked on that. Thank you very much, Marlene. I appreciate your support. And Rena, thank you very much. I appreciate you. You know that always. Good to see you. And we have a new member, Cassie. And you know what you get with that membership, Cassie? A toaster. No, you get nothing good, unfortunately. We're going to plan to do some private shows. I just didn't know if we had enough members to bother doing a private show just for the members, but maybe we'll do that for fun, even if it's only 15 people that show up. We'll do that. And Tom Fleming, as always, thank you, my friend. Thank you for kicking my ass in fantasy last week. Fantasy football, before really, really wants to go run with that and try to turn it into I said something else. I mean, there ought to be a way to be, and there are, I'm sure, for thousands of defense attorneys in this state, to make a living and not have to grift, to cover things. Look, Melanie is not officially part of Karen's defense team, and she's certainly not a part of Aiden's defense team. So act like an objective lawyer. Talk about some of the issues. Give us some legal analysis. You don't have to be a constitutional lawyer. I'm not a lawyer at all. I'm able to attempt it. So do that. Don't just sit there and make faces and cheerlead. It was worse on the Glarus channel. God, it was. I don't know how people could watch that. He actually had a little cheering thing that he would play whenever when a Turtleboy's lawyer said something, a little boo soundtrack that he would play periodically through the Cosgrove or through the judge. Wow. It's just unbelievable. So we are at the time that I thought Kate was going live. So we'll give it a few more minutes, and I'm going to go watch the Celtics game. And so, but let me just look in chat and see if you guys have any comments or questions you want me to go over and give you my bartender analysis of it. Jen says we have more members. Also, yeah, maybe we do have enough members for private chat. Let me see if I can. Been a long time since I looked at that. Let's see just how big we are. No, I'm going to guess we have I'm going to guess maybe we have about 70 members. So let's take a look at that. We have, where do I find this information? We have 7,856 subscribers. I don't know. I can't see the membership number. This is kind of a cool number. So average view duration on this channel is 32, almost 33 minutes. That's a good number. That's a good, because you realize a lot of people are going to come in on any channel and click for a few seconds and leave. So that's a pretty good number. But I can't find the membership number. What could it be under community? Comments? Nope. YouTube is a labyrinthine place to go around. So we've added 132 subscribers in the last 28 days. That's a little above average, so that's pretty good. And I still cannot find any numbers on the members. That's how YouTube is. You can search forever and ever. And if you're lucky, you'll find it. Fortunately, thank God for ChatGPT. When I really need to do something, I can go into ChatGPT, and it's getting better all the time at being able to answer questions on how to find things. Yeah, I don't find. Let's see. Let me try the dashboard. Give one more chance. Nope, not going to tell me here either. Yep, just not going to tell me. Members, let's see. See all members. Oh, actually, we're up to 98 members. Wow. Thank you, members. I appreciate it. Appreciate having you here. So maybe that's enough that we could do it. Thank you, guys. All right. If I missed a good question, let me go back and look here while I was searching there. So Chick from the Bricks. We did, as you know, that data sheet that we put together that correlates the vehicle data timeline with John's phone stuff. Hopefully they won't need something like that, because hopefully they'll get that data. So I think today they began that process down in Texas of updating those chips, or maybe it's on its way down to Texas today and over FedEx overnight, and it'll get updated tomorrow, and then they have to solder those chips back onto the boards, and then bring them back to Massachusetts and put them inside the Lexus. So Scott Robertson, thank you very much. Appreciate it. And Jack D, new member. Thank you very much. Welcome aboard. So that probably gets us up to 99. One more member, and we'll hit the magic number of 100. If we can hit that 100, I don't know what happens. All kinds of bells and whistles go off. A parade of elves will go by behind my back. So when do I think the data will be available? So the Brennan had said pretty much that they should have that within a few days. So they were going to schedule the chip off a few days after the boards were put in the car. But everything is rushed now because the trial has not been postponed. Thank you, Percy. That should get us to 100. The trial is scheduled for January. So they need to get this data, and they need to get it into the hands of, thank you, Thomas. They need to get it into the hands of, Ashley, thank you. We got 100 guys. Thank you. They need to get that into the hands of both sides, the experts, so they can analyze it. So just as a matter of fairness to the defense, if there's new information in that data, they need to have time to evaluate that. Annie, thank you very much. Welcome aboard. Good to have you. We definitely have over 100 now, so we'll schedule our first. Do we try one of those before? I don't know. We'll schedule our first private members only show, and what should we do for the private show? But anyway, so back to so they're going to have that information, that new vehicle data, soon. The question is when will we know if they got anything new on it? I have no way of answering that. But there is a hearing scheduled. I think it's called a Dauber hearing on December 12th or December 13th. And that's to question Dr. Russell to see, you know what? Let's look up what a Dauber hearing is. So the dude actually has a serious question. All right, good. What will these YouTubers say when Karen is convicted? Will they take accountability? I can tell you what they'll say, right? Dude, they're going to say, hey, we were just defending the rights of all defendants. That's all they're going to say. Now, it would seem a little surprising to me. I know we know in the Turtle Land, a lot of these people are going to just go on that it was all rigged and the whole thing was a frame job from Get One and you know, Kate Peter playing John's death and this. I mean, it's just crazy. But I don't think too many lawyers are going to say that. But you might see some of these lawyers talking about, you know, rights, appeal, the appellate process, and you know, could Karen get a new trial and that kind of thing. So they'll find ways to continue the grift. Let me ask Chat GPT. Specifically what a Dauber hearing is. Okay. A Dauber hearing is a special court session where a judge determines the admissibility of expert witness testimony. The hearing is named after the landmark U.S. Supreme Court case, Daubert versus Merrill. Hold on. The purpose of a Daubert hearing is to ensure that the scientific reasoning and methodology behind an expert testimony are reliable and relevant to the case. So in the voir dire, so Dr. Russell emerged in the middle of the trial. And coincidentally, she is from Los Angeles, and she reached out to the Los Angeles District Attorney's Office, where Alan Jackson used to work. Maybe that's all a coincidence. But Dr. Russell in the voir dire was questioned on her qualifications. So it looks to me that her qualifications are not challenged in a Daubert hearing. What's challenged, to repeat, the purpose of a Daubert hearing is to ensure that the scientific reasoning and the methodology. So they want to know not just whether Dr. Russell is qualified, but what methodology did she use here to determine that these are dog bites? Because that was not done at all in the voir dire or in the trial that I remember, anything like that. So what was the scientific reason? Actually, I take that back. They did do a little bit of that in the voir dire, if I remember right, where she pointed out to specific lines and parts of the wounds on John's hand and on his arm. And she said those are typical of a dog bite. So, and it's not like she has to do testing here. She's not able to do testing. John, you can't do any testing. All you can do is the photos that were taken as part of the autopsy. So she's going to look at those and based on her experience, offer an opinion. So I think it's going to be a little bit difficult to get Dr. Russell removed based on that, because once you establish that she's qualified, she was an emergency room doctor who spent a long time looking at, she even did some peer reviewed research or publication, public articles on dog bites. So her qualifications are there. And then she's going to say, well, I've looked at a lot of wounds, and this to me looks like a dog wound, and this is why. And she'll explain why. She did actually do that in the voir dire, now that I think about it. So, but does this give the prosecution the chance to present her with some more evidence and say, well, if you know that, for example, there was no canine DNA, does that change your decision? Now, again, that came up a little bit in the trial too, and in the voir dire. So I don't think it's probably going to affect much here. But so I'm curious. I mean, unless they're going to try to present some kind of new evidence. I don't even know if they can do that. Maybe Chloe will come to court. Maybe Chloe will be presented as a witness on December 12th. And Dr. Russell will get to look at her mouth. I'm kidding, but I don't know. What kind of new evidence could be presented here? Is that is that something that could happen? So just a little bit more on the Daubert hearing. Key points of a Daubert hearing: scientific validity. The judge evaluates whether the expert's methods are scientifically valid and can be tested. But in this case, it's just that you can't test it because you're talking about her experience looking at wounds. Peer review. The judge considers whether the expert's work has been subjected to peer review and publication. I think she was, but I'm not, error rate. The known or potential error rate of the expert's methods is assessed. Oh, so that would be interesting, right? But again, wouldn't that have been brought in during the voir dire if they found some reason to challenge her qualifications or her judgment on this? Standards and controls. The existence and maintenance of standards controlling the techniques operation are examined. General acceptance. All right, so let's ask ChatGPT. Can new evidence be submitted to the expert at the Daubert hearing? And the answer is yes. New evidence can be submitted to the expert during a Daubert hearing. The purpose of a Daubert hearing is to evaluate the admissibility of expert testimony, and this often involves examining the evidence and methodology that the expert used. During the hearing, both parties can present new evidence to support or challenge the expert's testimony. The evidence can include scientific studies. So if this is the case, I don't know why you wouldn't bring the ARCA guys up and do the same thing. I don't even know if the ARCA guys are going to make an appearance in the next trial. But why wouldn't you bring up the ARCA guys and say, here's the tech screen. Look, fellas, you didn't have the vehicle data. Here it is. Does this influence your decision? So I don't know. So could you do the same thing with the ARCA guys? And why aren't they? Beat Chance says, ARCA, I built a cannon. Really? Really, Beach Nance? Really? I'm kidding. Yep, exactly. They built a cannon. It was a murder trial, but they had a lot of fun. Oh yeah, that's right. I forgot. People reminded me I was supposed to pay attention to the I think the people in green in chat are the ones that are members. So I will try to pay extra attention. Celtics up 10. Thank you, dude. Yeah, the Heat kind of sucked this year. They're well past their prime. Jimmy Butler's great player, but old. I mean, actually, they need to trade Jimmy Butler to a contender where he can play in big games. He is a big game player. And that's what they need to do. He'll never come to the Celtics, and they're already loaded, but I would love to have Butler on the Celtics. He's really the one thing the Celtics have as a clutch player late in games. Mr. Anderson said they started the testing in Texas on the chips from the Lexus. So we know there was listed as December 2nd and 3rd. And so whether that takes 2 days or whether the second was to FedEx that stuff down there, I don't know. Empire says Arca got paid $500,000. That is a very expensive cocktail cannon that they built. Wow. Did they really get paid that? Damn. Yeah, Gracie says she had no method. She just looked and guessed. But I would say that that's all you could really do here is take your experience and look at something. So in her defense, I'll say that. I don't know what else she could do. Kevin, you idiot. They have 3 PhDs. No one is questioning the qualifications of the ARCA guys. Nobody. Well, I don't. In fact, it was kind of a funny moment, my crime time. So in the summer, a couple months after the trial, I went to a hearing outside of Dedham. There was several hundred people out there, blue shirts, pink shirts, and I was with the blue shirts, of course, but I walked over into the sea of pink, and started to make some conversation. And once they saw me in there, and the state police kind of kept it separated. So you had the courthouse stairs, and that there was a brick area that leads from the stairs to the street. So on one side of the sidewalk, the sidewalk was all blue, and on the other side, the side was all pink. And in the middle, patrolled state police, maybe half dozen, to make sure that there was no trouble. And there wasn't any trouble ever down there. But I walked over and just politely started talking to people in the pink. But I was within the pink part, but close enough that the police could tell I wasn't looking to start trouble. Although they did eventually pull me out. So LTL and Mazda Media came over and went live and started asking me questions. Said, sure, I'll take your questions. And Brian, being disrespectful, Kevin, do you believe the world is flat? I said, come on, what is it that you want, Brian? He said, science proves that these guys, that John's injuries could not have been caused by a vehicle. I said, that's not true. He said, do you think those ARCA guys are unqualified? And they were all shouting questions at me. The whole crowd pressed in. And finally I said, hey, do you want me to answer the question? I'm going to answer the question. And when they were all silent, I said, those ARCA guys are eminently qualified. They're the best of the best. And they weren't expecting me to say that. But that's what I said. I said, these guys are the best of the best. They're PhDs. They know how to explain the science behind these things. These guys are truly elite. And they were stunned, right? And I said, the problem is not their qualifications. The problem is their credibility. The problem is they were not seeking the truth, and there's evidence of it. So these guys never were given and never sought the vehicle data, the tech stream vehicle data, the tech stream. Now, on their website, they have an article that claims that they are experts in tech stream data. And they even shows how vehicle data that could not have been recovered on a normal crash situation, that wasn't recovered from the black box data, can be recovered by tech stream. So they knew this. Sorry, just checking the messages. These guys knew that this was a Lexus. They're experts in tech stream. They weren't given the tech stream. They didn't ask for it. Now, this is suspicious. If they had that tech stream data, it would have definitely altered their conclusions. Now, for an accident reconstructionist to do an accident reconstruction without looking at the vehicle data is really the equivalent of a medical examiner doing an autopsy without the body. It's the most important data. The most important piece of evidence is the vehicle data. These guys were building a cocktail glass cannon and testing it at various speeds to see what speed it would take for that glass to break the taillight. but they would need to be able to know the speed of the vehicle to do that. So, obviously, if the car's coming at them at 15 miles an hour, 20 miles an hour, you'd have to. And the idea was they were thinking that John had thrown the cocktail glass, but you have to do that combination of things to establish that. And there's all kinds of other reasons, but you really just need to know that vehicle data. And those guys had no interest in it. That's highly, highly suspicious. And so it's a situation where obviously the feds, you're not going to find an example where the feds, Josh Levy, sent them an email saying, hey, we really want you to help us create reasonable doubt for Karen Reed. No, they're not stupid. They're probably not even going to say something like that verbally. It's kind of done with a dog whistle. It's basically like, look, we've taken on this case. We have reasons to believe maybe the investigation was corrupt. We're putting a lot of effort into it, and we want to task you with looking at whether or not the victim's injuries could have been caused by a vehicle or not. But they only took that case like anybody because they were interested in the idea that the investigation run by the state was corrupt. That's the only reason the feds took that case. And that they believed that was likely was the signal that they gave to the ARCA guys in hiring them in the first place. But then they affirmed that signal by not giving them all of the data, by not giving him the text string. That's not an accident. It's not an accident that Josh Levy didn't send the text string. He wanted to give him just enough that hopefully he could get the conclusion that he wanted. And he did. But what I'd like to see here is if you could, I don't doubt the qualifications of the ARCA guys. So take those ARCA guys, give them all the data, give them the stuff that they need, and see if they come up with the same conclusion. We can't. I don't want to predict what their conclusion would be, but especially look, we see in any of the, not just this case, in any cases. Look, for instance, say the O.J. Simpson case. If you go back and look at that, the defense team hired some of the top retired police investigators in the country to testify for O.J. Simpson. I don't question their qualifications, but they were hired to do a job, which was to help OJ get off. And if they succeeded in that, they stood to make a lot of money. And that's what they did. They helped get him off. So if that sounds conspiratorial, me saying something like that, it's not really a conspiracy. It's just people know where their interest is. And most people do what's in their own. So unfortunately, most people do, or many people do what's in their financial interest and not what's right. Integrity is kind of rare, but it's certainly not difficult to find experts that are willing to come forward to have their 15 minutes of fame and to use that to make some more money. Again, I'm not accusing anybody specifically. Is that what goes on with Dr. Russell, with the ARCA guys, with Rich Green? We can't know, but we have to know that that's how the system works. We have to know that that's not uncommon. And I'll tell you what, Turtle people may not know that, right? Free Karen Reed people may not understand that, but that jury understood that. Because if that jury bought into what those experts were saying, or even thought, let's not even say they bought it, let's make it weaker than that. If that jury believed that there might be something to what those experts were saying, Rich Green, the ARCA guys, Dr. Sheridan, and Dr. Russell, if they even thought there might have been something to that, then Karen would have been acquitted. But those jurors, and I haven't talked to any of them. The only information I have is what from Turtleboy's 2 articles. But those jurors obviously had the common sense understanding of how it works. Defense teams are going to find these experts, and that's just the way it is. So they dismissed it. They did not find it to be compelling. Certainly, at least 9 of those jurors did not find it compelling because they ended up voting for guilt on the manslaughter charge. And if any one of those experts impressed them as either credible or competent enough, then they would have voted to acquit. and 9 of them did not. So, and even of 2 of the ones, well, one Turtleboy interviewed one of the jurors that had voted to acquit, and that juror did not seem to factor in anything. Didn't talk about the dog bites. Didn't talk about Dr. Russell. Didn't talk about the ARCA guys. And then there was the other juror he interviewed was someone who was started out as not guilty on manslaughter, but eventually switched to guilty on manslaughter, but clearly had some questions. And that was an EMT. He came across as competent and sincere, and he had some questions, right? But the ARCA guys didn't affect him at all. So why? He didn't know that they were hired by the FBI. That might have changed things for him. But what did he do? He, in his mind, because it's the defense that called on him, these are typical of defense experts. And so he had enough common sense understanding about how the system works to say, there's a good chance that these guys are shading their testimony. Let's put it that way, if that's a fair way to put it. All right, so let's take one more question and then go to the Celtics. Jimmy McNutty says ARCA was hired to link Karen Reed's case to Sandra Birchmore. I don't know how, but there was, because those are accident reconstruction guys. I don't know. Well, the question, at least, is if Dr. Russell gets dismissed, can they find another dog expert? Because here's the thing. She didn't emerge until the middle of the trial, and they had their theory for at least a year. And really, it sounds like, if you believe Karen's story, more like 2 years, that they had the theory that John was attacked by a dog. So they had 2 years to try to find an expert that would support that, and they couldn't until Dr. Russell miraculously emerged during the trial. Kelly points out that one of the ARCA guys, their wives, was posting during the trial, or right after the trial, anyways, proffering in the Karen Reed Facebook group, and so pretty proud of her husband's testimony. I don't know, hard to know what that means, but can they find an honest dog expert? Yes, the state. My understanding was this last time the state had one, a really eminently qualified one, but it was going to cost $22,000, and they didn't want to pay. This time they're going to pay. So because they didn't, they cheaped out on the first trial. Now they have to pay all of it over again. So that's the problem with cutting corners. So someone just said the dog expert. I mean, sorry, the state needs to hire the dog expert that Melanie Little had on the show. And I did see that because someone had sent me a link to it. And it was great to watch the look on her face, because it wasn't what she wanted to hear. But yet, so you got to give her credit for having that person on the show. But I don't think that she knew that person was going to say that. And it doesn't change anything. It doesn't cause her to ask any questions. I mean, if I'm covering this, if I'm Melanie Little covering this, and I'm really just sincerely believe that Karen was innocent, and you have a medical examiner come on to say these injuries were probably caused by a car and that was aren't dog bites, wouldn't that be enough to make you say, well, maybe I really got to start questioning this more from both sides? But that doesn't seem to happen to people like Melanie, because it's all grifting. There's no both sides question. I'm not saying that Melanie Little has to agree with me. I'm not saying that Melanie Little has to conclude that Karen's guilty. No, not at all. What I'm saying is Melanie Little, if you're going to, I personally, anybody that's going to be a journalist, a law tuber, try to look at anything from both sides. Otherwise, you're just grifting. I started out more on the other side, but I was never fully on the other side. I was asking questions because you didn't have enough evidence, right? So you keep asking questions. Not only didn't have enough evidence, but I was ignorant about too many things about how these investigations work, about vehicle data and stuff like that. So, you keep asking questions. There were things that seemed odd, no question. But then there were also the logic of the conspiracy theory was ridiculous. So you keep asking questions. That's the way I think you have to do it. Turtleboy 2, whose name I know, but she probably doesn't want it said, or he will have a bachelor's degree by the time I'm 60. Good for you. Good for you. That's awesome. Never stop trying to grow. Never stop trying to chase your dreams. Never stop trying to get better. Try to improve. That's awesome. Doing it because of TB. Well, hopefully you have more reasons than that to do it. But Jackie D says it's up to 192 conspirators. Probably. Tommy Bernhard says that the vehicle speed is the number one factor needed to calculate the impact. So ARCA absolutely knew speed. How do they know the speed? They didn't know the speed. They didn't know the speed. Dude, I don't even, Tommy, they didn't have the vehicle data. How could they know the speed? That's crazy, man. You're the one that's misleading people here. That's ridiculous. They didn't know the speed. How could you know the speed without the vehicle data? Come on, man. All right, so let's go to Curtis's question. Is there any chance in the universe that Karen did not hit John with her vehicle? It's a reasonable question, especially depending on how long you've been following the case. All right. Just let me answer Tommy first. They're estimating, they're guessing. There was not enough evidence. You're saying they knew the speed. They could not have known the speed. They took a guess at how fast the taillight glass was. The cocktail glass was going because they thought that that's what broke the taillight. And that's why they created a canning. But they were just guessing. And it turns out that the state's theory is that it was not the cocktail glass that was broken it. So they have no idea what the speed is. They presented no estimate of what the speed of the vehicle was. In fact, why would they? Because their theory was they didn't think the accident was that John's death was caused by the vehicle. So why would they know that? Ah, dude, you're exasperating, man. You are exasperating. No, what they said was that above 15 miles per hour, a vehicle impact with a body does significant damage to the car. But that is not the same as saying that they were estimating that the car was going 15 miles an hour. It's not what they said. They had no idea. So you're just putting stuff out there that's crap. All right. Lycurgus, is there any chance the universe Karen did not hit John with the vehicle? All right. Here's what you have to know. John's phone did not go inside the house. I'm not going to argue it here because I've argued it too many times in the channel and they've all heard it before. But John's phone did not go in the house. That's a fact. That's not something that's really open to debate because it's GPS information. The GPS shows that the phone did not go in the house. And that the phone was found underneath John's body at the far edge of the property, a few feet from the street. So to believe that John went in the house, you have to somehow explain how he ended up on top of his phone on the edge of the property near the street. So is that technically impossible? Is there any chance in the universe? Well, there's probably some way, right? But you have to come up with some theoretical way that could happen. But that's not the only evidence. In addition, the vehicle data shows 2 triggered events. Now, these events don't have timestamps. We might get those timestamps with the new data. But for now, we have to go with what they have. They weren't able to get timestamps. So, but what we do know, at the same time that was going on, John had activated his Waze and put in 34 Fairview, so from a mile away as they were driving there. Okay, now that's also the same time that that John was allegedly going up and down stairs. It's impossible because we know where John was when he put into Waze the address for 34 Fairview. And they were a little over a mile away. And it was only, which is, say, 4 or 5 minute drive away. But it was only a minute or two after that they started registering John going up and down stairs. It's impossible. There's no way they could have got there that fast. There's other reasons that it's impossible. We know from the GPS where John was at that time. The state knows that. So they would actually know exactly where. It wasn't Cedar Crest Street. It's the name that, it's the street that led to Cedar Crest. I can't recall it at the top of my head, but they know roughly where that phone was when the health app first began thinking it was going up and down stairs. So there's 2 triggered events within the vehicle. Now, what do I mean by a triggered event? Just check one thing first. All right. Your vehicle data is tracking, is taking in multiple sensory inputs. How far you push the gas down, the speed of the vehicle, and all kinds of other stuff in your car. Doesn't have the memory capacity to record all of that. So what it does is it's basically recording a continuously for 5 seconds, and then it writes over that. However, if something triggers an event, so like let's say you're driving and you strike another car, that causes that 5 seconds that it's just recorded, that creates a record of that 5 seconds, and it creates a record of the next 5 seconds after the event was triggered. So what you get is a 10-second snapshot from the event. So you're driving down the street and you drive into another car. The event that is created in the data, which is the word is triggered, the event that's triggered in the data creates a 10-second snapshot, 5 seconds before and 5 seconds after. And that's it. It doesn't record outside of that because it doesn't have the data capacity. It doesn't have the memory capacity to do that. So, but it does create that event in there. So in the entire history of Karen's car, there were only 2 triggered events, and they both came that night. The second event came 8 minutes and 4 seconds after the first event. Now, the first event displayed, but when they look at the gear switching and all that, what they identified as a 3-point turn, or basically a turnaround. We know that Karen had to make such a turn because when she was following Waze, she missed the turn from Cedar Crest onto Fairview. She missed it. So you know how it is with Waze. You missed a turn and it recalculates. So we know the exact time of when she missed the turn. And then it recalculates and starts to give them new directions or tells them to turn around. But in any case, they decided to turn around. So that's when she did that 3-point turn. But because she must have been angry or drunk, she hit the gas more than 30% while the car was in reverse. And that people don't normally do that. And so that created, the algorithm is to say, okay, there's something going on here because someone is slamming the gas in reverse. And that created an event. That triggered an event. That's the first event. The second event comes 8 minutes and 4 seconds later. Now we know because of, we're also tracking, we know roughly what time the 3-point turn was on Cedar Crest. We know within, say, 5-6 seconds because we know what time she took the turn, missed the turn onto Fairview, and then took the turn onto Fairview. So in the middle of that, that's where the 3-point turn was. So that's roughly at 12:24. I would actually try to say it's probably 12:24 in 2 seconds, 3 seconds, but it's roughly 12:24. Give plus or minus, say, 5 seconds. 8 minutes and 4 seconds after that, another event is triggered, and this time she is also again from punching the gas while in reverse. So the accelerator is depressed 75% in reverse. That triggers the creation of an event. In that event, it's a 10-second event, as it always is. You get the 5 seconds before that event, before she hit the accelerator that hard in reverse, and you get the 5 seconds after. So in the 5 seconds before, what you can see is she's going forward, and then suddenly so she's going forward for a few seconds, and then suddenly she stops, puts it in reverse, and goes backwards and punches the gas. Now, 5 seconds after she punches the gas, now that comes 9 seconds into that 10-second event that's created. That's where you have the telltale signs of a pedestrian strike. Those signs are the vehicle slowing down about 0.6 miles an hour because a smaller object slowed it down, and also it also you have a jolt in the steering wheel where it goes from left 4 degrees to right 4 degrees. And that is known to experts as the telltale signs of a pedestrian strike, of a large vehicle striking a smaller object. So we know, again, from the timing, the second event was 8 minutes and 4 seconds after the first event. And the telltale strike was at the 9-second mark. So 4 seconds after the triggering. So what that means is that John was struck 8 minutes and 9 seconds after the 3-point turn on Cedar Crest. So we don't know exactly what time that turn on Cedar Crest was, but we know within, say, 4 or 5 seconds. So if we're putting that turn on Cedar Crest at 12:24, then John was struck at 12:09. I'm sorry, 12:32:09. So 8 minutes and 9 seconds later. Now, like I said, putting it exactly in the middle would put that 3-point turn actually at about 12:24:02 or 12:24:03. So that would mean that John was struck at 12:32 and 11 or 12 seconds. So around 12:32 and 11 or 12 seconds, that's when John was struck. Now, proving that, or further solidifying that, is that John's phone moved, according to the motion data, for the last time at 12:32 and 16 seconds. So just 3-4 seconds after the vehicle data shows he was struck. 3 or 4 seconds after the vehicle data shows the standard telltale sign of a pedestrian strike, 3 or 4 seconds after that, that's when John's phone last moves. So when you say, is there any chance in the universe that Karen did not hit John? I give you that evidence there. Now, there's a lot of other evidence too. You have a massive amount of evidence at the scene that is connected to Karen's vehicle. And the only way that could be there was if there was a massive effort to plant it. And there just was no opportunity to do that. When you look at where that vehicle was all day, there's pretty much no opportunity to do it. And so by the time, and so the defense has tried to theorize that the troopers smashed the taillight in the Canton Police Sally Port when it was taken back. But it didn't arrive in that Sally Port until 5:36. And the Sally Port door didn't close until 5:41. Well, at that time, the 7-man state police CERT team is digging in a small area the size of 2 parking spaces. They're shoveling in that area, and they find the main piece of taillight 3 feet down at ground level in a snowbank at 5:45. So there was no time for anybody to race those pieces over and bury them 3 feet down in the snow. So the only way it's even possible is if all those state troopers at the scene were in on it. So again, you ask, is there any chance in the universe? That's the evidence that I present to you. And you can decide, is there a chance? I mean, are we looking at a 1 in a million, 1 in a trillion? I don't know, but it's very long odds against all of that stuff. So calculate it that way. more evidence was found later, Jeff, as the snow melted, because now some people that might be from Florida, one of my good, very best friends, Dina McKinnon, very rarely gets to see snow. She lives in Jacksonville. So for people like Dina, I can tell you, I can affirm, because you may not have direct experience of it, Dina, but snow does in fact melt. We have a certain crowd up here that doesn't really understand that, but there's a lot of things they don't understand. But yes, snow does melt, and there was a record-setting blizzard on the night John died. It was in January, but we call it a January thaw, but it comes January, February. There's always going to be a couple of days where the temperature gets in the 50s and you get a lot of melting. And that's what happened here. So Tommy's just going to keep ignoring evidence and common sense as long as it takes. And that's all you can really say. I don't want to give him more attention than that. Right. So Mitch Beach Lover says a few days later, it went up to the temperature went up to 53 degrees. And they knew there were more pieces out there. So they had instructed Canton police officers to keep your eye out as you're driving by for pieces of taillight. And so you had a high-speed impact, presumably with John's elbow. And so most of those taillight pieces were going to land in a spray pattern, but not all of them. There's always going to be outlier pieces. So one piece was found over near the fire hydrant, which was 30 feet away from where John was found. How did it get there? We'll never know, right? Did it bounce there after bouncing off something? That's what happens in an explosion, right? Did the wind put it there? Because you did have 50-mile-an-hour winds before the snow fell. Could the wind have blown a piece like that there? I don't know. Did a plow move it there? We'll never know. But there's always outlier pieces of evidence like that. Tommy, you're ignoring all the evidence that I just gave you. You're ignoring the fact that the vehicle data correlates perfectly with the data on John's phone. And you're going to just talk about weird things about when the evidence bag was dated. I mean, all of that was explained in trial. There was nothing mysterious there. There really wasn't, dude. So you're looking for reasons to believe in a conspiracy. For some reason, it's important to you. I don't know why. It's personal for everybody. There are people that have personal reasons to really, really, really want to believe in this stuff. And it's like that with a lot of things in life, right? People really, really want to believe in UFOs. Hey, I kind of want to believe in UFOs. It'd be fun, but it's not a religion to me. So I'm not going to let it affect the way I skeptically interpret evidence. You really, really, really want to believe in this. So you're going to dismiss the GPS data, which shows that John's phone never went in the house. And you're going to dismiss the way the vehicle data correlates. And you're going to make me discuss things that are irrelevant, like when the evidence bag was dated. And I'm sorry, I'm not trying to be disrespectful, but you're firing away a lot of comments here. And I don't mind engaging, but then it's unfair to other people. And I just don't think you're after the truth. You're not. You may think you are, but you're dismissing the most important and fundamental piece of evidence here. And so you're the guy that said that. All right, now I remembered. You're the guy that actually bugged me when I was after a long show and I was tired, and you kept insisting that there was no way that vehicle could achieve 24 miles per hour in the time that it did. So as tired as I was, I went on to ChatGPT, plugged in the data exactly the way, and I had already plugged it in before myself, just a week before, but I had used the Lexus model in, and you didn't want that. You said you got to put the weight of the car in. So I put the weight of the car in, and it came up with the 6,000-pound car with the accelerator depressed at 75%, which is the data. How long would it take that vehicle to reach 24 miles per hour? And what ChatGPT calculated was 4 to 6 seconds, which is exactly what Trooper Paul calculated here. So, I mean, it just, at some point, you just don't like the results of this stuff. And I mean, the evidence is there. It's like, I don't want to waste too much time. I already wasted that time. I put it in there, and there, you helped me prove it to everybody else that Trooper Paul was right. All right. So thank you. Thank you. You helped me prove, you helped us all prove that Trooper Paul was correct, that you, Tommy Bernhard, was wrong, but accept the results. The math is there. Just accept the results, but you don't want to. It's like somebody that really insists on the resurrection after the third day. They don't need evidence. It's faith. It's a matter of faith at this point. So, all right, guys, I'm going to go watch the Celtics game, and thank you very much for being here, and apologize if I sounded aggravated. I'm not. So everybody be good, and we'll see you all soon.